can defy the federal government to smoke marijuana, we can defy the federal government and save these babies. Welcome to our first episode of Capitol Conversations. I'm Dennis Sarfate. This is Zach Lautenschlager. We're here at the State Capitol building in Harrisburg, Pennsylvania. Beautiful building behind us. Tomorrow we're actually holding a rally here, but today we're going to have a little conversation first. And let's talk about the amicus brief and let's talk about the Mississippi case.
Right, so we have a current case active before the Supreme Court to which we are part through an amicus brief. That means friend of the court. This is the case of Mississippi versus, no, excuse me, the case of Dobbs versus Jackson Women's Health. And so the issue at question at the core of this case is a Mississippi law which restricts abortions, actually bans abortions before 20 weeks, down to 15 weeks. Now, we're not necessarily huge fans of that particular law. If it is upheld and if it can be enforced, it will save some babies, and that's a good thing, praise God. But of course, we are wanting to end abortion. Our goal is to abolish it. And the reason this case is a positive for us is because it is the opportunity to potentially, number one, overturn Roe. Roe is actually bound up in what we refer to as Roe in several cases, including the 1990, I believe it was 92 Casey court case, in which it was ruled and handed down that any ban that takes effect before 20 weeks is a prior restraint on a right to abortion, and is actually the intent of which the court ruled is to end abortion rather than just regulate it. Of course, that's an outrageous ruling, and it's always important to point out that the Supreme Court does not make law, is not equipped with the authority, is not clothed with the authority to make law. And as Justice Clarence Thomas has said multiple times, the right to abortion is itself a made-up idea. It's completely false. We have multiple Supreme Court justices saying that, and of course, the majority of Americans agree. And so, what's being called the Mississippi case, or the Dobbs case, which the oral arguments will be heard on December 1st. It will, first of all, challenge whether or not this notion that states can't regulate abortion, can't restrict abortion, is valid. Of course, there are many people who have strong hope that the court will overturn Casey and Roe, which, if it allows us to stand, will overturn all the case law up to this point, which has all been focused on 20 weeks. So that's where the 20-week bans come from.
So let's talk about the Supreme Court a little bit. You know, a lot of people always have their hope in the Supreme Court overturning it. Why do you think that the Roe v. Wade has taken on the appearance of law when everyone knows that Congress passes law? This was never voted on. This was just a court opinion. How did we get here? It's 2021. How did we get here and say, wait a second, when President Biden even said, I have to codify it? And how do we get to the point where we say, oh, each state, we already know it's not law. We have to move past this. You know, the Supreme Court's not going to change abortion, right? We had, it was a Republican-dominant Supreme Court when Roe v. Wade was passed, and in the Casey case. So our hope is in the Supreme Court, but really it should be back on the people and the church saying, no, we're going to hold our state, local magistrate accountable to what we're trying to do. And that's why it's a state issue.
As you pointed out earlier, Justice Clarence Thomas has already stated, and as have other Supreme Court justices, but Thomas said it best, that abortion is itself supposed to be restricted and ended by the states. Now, he used the word restrict. He said it's not only the states' right, but their duty to restrict and end or completely outlaw abortion. This is something in American jurisprudence, it's always been the case. The idea that nine Supreme Court justices could find a right to abortion in the penumbra of the Constitution, which penumbra simply means shadow. So they're saying that it's not even there. We're admitting that it's not even there, but we can imagine that it is, and so it is. And so the reason, you asked earlier, how did we get there? Well, we got there because when the court ruled, there were both the politicians in the Congress, in both Senate and House, and all the politicians in the states said, oh, well, I guess that's what we have to do now. It was a great way for them to avoid responsibility and accountability on a controversial issue in which there were real consequences for standing against abortion, because we already had a well-funded, well-organized abortion lobby that could cause political pain, and so gave them the perfect out. That's how we got there. And what happened in the next elections, the following elections, since before that, the idea of the court being able to make law existed obviously before 1973, but on that abortion issue, then in the elections after the Roe decision in '73, people allowed their politicians to say, well, there's nothing we can do.
Mm-hmm.
That's a laughable notion. It's absurd. It's ridiculous on the face of it. We can look at major issues like slavery and see that the states, when they wanted to, stood up to the Supreme Court, especially in the cases in the 1850s leading up to the Dred Scott decision,
Sure.
as you know.
Yeah.
And I mean,
what about even take it to the modern day marijuana, right? We have states that say, you know what, we know federally it's not mandated, it's illegal, but here in our state, 38 states now, you can smoke marijuana legally in their state, where federally it's illegal. So this is what we try to do when we go into state reps in each state. We're like, this is your responsibility, that you have the right to tell the federal government, first of all, Roe v. Wade is unconstitutional, it's not even law, we're going to defy that, and the state sovereignty, we're going to do it here locally in this state. And I think that's the angle we have to take.
well, it's very important because, it's not about marijuana. Of course, legalizing marijuana is not the point. We're not saying that's necessarily even a good idea.
Yeah.
That you can have your opinion on that, we can all discuss it, but the point is you have 38 states now that are telling the federal government, no.
Mm-hmm.
They are ignoring federal law, they're ignoring federal court precedent, they're ignoring every aspect of federal regulation on the possession and use of marijuana.
Yeah.
So one way or another, not saying all 38 are the same, obviously there's a lot of variety there.
Sure.
But obviously, states are able to contravene and contradict federal law that's actually duly passed by Congress,
Yep.
along with all of the case law surrounding it in the courts, and say, yeah, we're not going to do it.
So the amicus brief in a whole is pretty much telling here the Supreme Court, stay in your jurisdiction, almost get back in your lane, so to say, the lyrics of these days, stay in your lane, pump your brakes, and let the states handle their business.
Our brief helps the court in two ways. Amicus means friend of the court. Mm-hmm. And so we are offering information to the court in two ways. Number one, we are pointing out to the court that previous courts have actually dramatically eroded the respect due to that legitimate constitutional branch of authority branch of government by contravening its own authority and going beyond it, taking authority from the president, taking authority from Congress, and they've been allowed to do that. But what that's done is create a dramatic disrespect for the court. You can talk to liberals, you can talk to conservatives, and there is disrespect for the court on all sides. Sure. That's a serious problem, and people who point out and say, well, we can't just ignore the Supreme Court. First of all, we ignore the Supreme Court based on the reality that they are wrong, as has often happened. But it's also the reality that when the court goes beyond its own authority, it makes a mockery of itself. Mm-hmm. And that's what's been happening on abortion for 50 years. Yeah. January of this next year will be 49 years. Mm-hmm. And so we make that argument, first of all, to the court, that we have love and respect for that branch of our government. We need to hold it accountable.
Sure.
And the current court needs to restore the respect to the court by returning the court to its lawful authority. Mm-hmm. Second, we also join Justice Thomas in urging the court to recognize that, of course, the states have a responsibility after 50 years of egregious wrongdoing and
Yep.
claiming that American persons who are constitutionally protected are no persons at all, and claiming that they may be killed with impunity. Okay, that is an egregious wrong.
It is.
And there are numerous precedents, the best of which is the laws and cases around and including the Dred Scott case, in which the upshot was black people aren't persons.
Yeah.
It's exactly the same case.
It's exactly what the Supreme Court ruled on.
They decided that the constitutional protections afforded to persons
That's right.
in America did not apply to black persons, and therefore black persons are not persons.
Yep, and they also even went further and said they wouldn't even be considered U.S. citizens.
Correct.
Ever. So that's a Supreme Court that obviously has a moral delusion going on.
It is.
And we have 66 million babies have been slaughtered through Roe v. Wade to the present day, 3,300 a day.
This is no small matter. This is the government refusing to do the one thing it's really supposed to do, and doing a bunch of things that it is not supposed to do, to the point of making itself a mockery. And thank God there were states like Massachusetts at that time which said, yeah, no, we're not going to recognize the authority of that ruling. It is so far outside what is right and just and true. It's so far outside the authority of the court that it is simply not law. Our founding fathers used the term under color of law, and it's still something you'll hear today. It's when officials who have the official responsibility and power to mold or shape some understanding or some portion of law, which the courts do, when they go beyond that and do things which they are not allowed to do and claim it as law, that is called under the color of law. Our forefathers recognized that standard, that immutable standard for law, comes from God's word, and that is the standard for what civil authority may and may not do. It's about jurisdiction. We can ask the question, well, should the mayor of your town be able to decide what parents can feed their children? I mean,
these days you never know, right?
It's important when children get fed. And I think you and I both agree that sugar Frosty Puffs are probably not good normal fare every day, twice a day, thrice a day.
You ain't finding those in my house, and I know they're probably not finding them in your house.
I'm finding them in my house, as much as my children would like it if those were there, right? But that said, does the mayor have the authority to tell every parent in the city, you can't feed your children sugar Frosty Puffs? I think not. I think that we would all agree that goes bad places. That goes bad places. Now, we can have a debate over whether or not that's a good idea. And of course, parents may choose to send their children to public school where government officials are deciding what your children eat, but that is a decision that parents make. This is not something that we're required to do, right? And we can even debate whether or not it's a good idea for government to be involved in that. But this is a clear example of jurisdiction. What if the government decided tomorrow that police should be able to, that all policemen have the right to prima nocta? Okay? This is an ancient tradition, especially in Europe and England, in which the lord of the manor, and it was often instituted in Scotland by England, so that English blood would be intermixed into the Scottish blood, and the idea was, we're going to cut the next generation. We're not going to have these rebels who refuse to knuckle under and give up their freedom. So in the days of William Wallace, the king granted the English lords who had been imported and imposed on the Scottish people the right of prima nocta, which means at every wedding the lord could show up and he got to sleep with the bride first on the night of the wedding.
Okay, is
that beyond jurisdiction? What if the Supreme Court ruled that was okay? Would the states be correct in saying, no?
We're not going to follow
We're not going to do that. The mayor, the policeman, whoever, they do not have the right to have sex with your wife on your wedding night. Okay? I'm sorry to say it that way, but that's the reality. It needs to be said carefully, but let's say it as it is. Okay? So, of course, there is a bound to jurisdiction. The question is, where are those boundaries? Everyone actually agrees. The left agrees that there are boundaries to government jurisdiction. They want them in a different place that justifies a godless and God-hating worldview. And so much so that they've created the notion that the courts are secular, which is laughable, really. So stop signs are secular? They're not based in morality, really. So if I run, is it wrong? How about if I run one and run somebody over? I run a stop sign and kill someone. Is that wrong? Oh, so law maybe does have a moral foundation. Maybe there is a moral foundation to law. And so that's where, we trace that back to saying, well, what about the Supreme Court? What about overturning Roe? Yes, of course we would want them to do that. What about the states? If the court continues to do what's wrong, what about the states ignoring Roe? Of course, yes, that is another avenue.
Absolutely. So that's why the amicus brief is so important. Bradley Pierce to even get an opportunity to file that was amazing. God's providence.
You don't just get to walk in off the street and file an amicus brief. You have to be certified before the bar of the Supreme Court.
You have to be
sponsored by a current member of the bar. And so
it has to be 9,000 words or less. It has to be on certain paper, certain number. And so it's an intense process. If you want to get involved with that, takeactionforlife.org. There is a petition on that page, End Roe v. Wade. You can go ahead and sign that and join us in that fight.
And that's the really exciting thing about this. You can actually become a signer of the brief. You can join the case. Your name will be listed in the official record. It will be there for all of time until the records of the United States of America fall into disrepair or are destroyed. So for hundreds of years at least, your name will be attached to ending Roe, either overturning it or ignoring it. And so simply by going to our website, doesn't cost you anything. Although if you want to donate afterward to support this work, of course we would appreciate that. You'll have opportunity to do so. But you can affix your name to this along with tens of thousands of other Americans so far. We're working for millions of Americans, and we are seriously and actually meaning to gather at least 1 million signatures, and those will be displayed to the court when they take up oral arguments on December 1st of this year. So time is actually very short. December seems like it's a long way off. You're talking about a few weeks. So please go to takeactionforlife.org and sign up to join the case to overturn or ignore Roe.
Well, that was a great first episode right there. So
There you go.
join us next time on Capitol Conversations, where I don't know where we'll be, but it'll be at a Capitol somewhere.